In Texas, one of the most important types of motions is a motion for summary judgment. The motion for summary judgment essentially tells the court, Your Honor, the other side doesn't have a case, they can't prove either their entire case or certain very specific elements or very specific causes of action that they have. There are two specific types of motions for summary judgment. One of them is a traditional motion for summary judgment. This can be filed at any time from the very beginning of the case. You have to give the other side at least 21 days notice, and they have to get their response in 7 days before the hearing. Now, in order to go forward on a motion for summary judgment, you have to prove what's called a prima facie case. This means you don't have to prove the whole case, you don't have to prove everything, you don't even have to put together a great case, but you have to put together enough that the judge looks at it and says, yes, I can see where that is a complete case. Now, in response to that, the non-moving side has to come forward with at least a scintilla of evidence. And it's not very specific exactly what a scintilla is, but it's definitely not very much. It's just enough to prove that, Your Honor, there is a question of fact in here. It doesn't mean that you have a better case. It doesn't mean you have a stronger case. It just means that there's a question of fact. It doesn't even mean that you've convinced the judge that your clients or that your witnesses are better than the other sides or that they're telling the truth. Just that there's a question of fact. It's not clean cut. We're entitled to have a jury make this decision. Now, there's also a non-evidence motion for summary judgment, and what that means is that the other side has the burden of proof on something, some issue, some cause of action, certain elements within a cause of action, and you're saying, Your Honor, they have the burden of proof. They don't have enough evidence to come forward and prove their case. Now, this is easier to bring forward than a traditional motion for summary judgment because there's no requirement that you come forward or that you provide a prima facie case like there is with the traditional motion for summary judgment. However, the traditional motion for summary judgment can be filed at any time. The no evidence motion for summary judgment can only be filed after a reasonable amount of time for discovery has occurred. Now, what is a reasonable amount of time? That's going to depend on a particular case. That's going to very often depend on the judge, but generally speaking, it means that the discovery period, which is the time that has been set up at the very beginning of the case, has expired. Now, so the benefit is you don't have to bring forward as much evidence to bring this motion, but you also have to wait longer. So, there's pros and cons, different factors that have to be evaluated to determine which is more appropriate for any particular case. Another distinction in motions for summary judgment are complete motions for summary judgment, which in effect end the case, and partial motions for summary judgment, where you're not saying that the case should be ended, but that the other side should lose on very specific elements or certain very specific causes of action in their case. Now, the benefit of bringing the complete motion for summary judgment, or the motion for summary judgment as it's generally known, is it ends the case. You've won it, it's over, you did great. You can't ask for more than that. But the downside is that if the court sees that you're not conducting a very careful analysis piece by piece, they're not going to be as comfortable just saying, okay, fine, you win. Most judges and most courts have a preference to allow the parties to have their day in court, to have a jury hear all of the evidence. Now, there are times where it's very appropriate to come in with either type of motion for summary judgment, and a lot of that's going to depend on the very specific factors involved. But if you can show the courts that you've analyzed this very carefully already, and here's very specifically why on very specific elements you should win, a court's going to be much more likely to go along with you and follow your reasoning. Also, this has the added benefit of reducing the issues at trial. It's going to involve less expense for you and your client. It's also going to put the other side in a position where they're not going to be in a position where they can confuse the issues. Say, oh, well, look over here, let's talk about this element. Look over here, let's talk about this element. Well, a lot of times that can get very complicated. So if you have very specific issues that are reduced by the time you get to trial, you're going to put opposing counsel in a box, and ultimately it's going to make it a lot easier to win at trial if you've already won certain parts of your case with a partial motion for summary judgment.